Hello, everybody. You are back again with us. Hope you're having a great day. We have, thank you. First of all, I'd like to thank you all. There's been at least 20, I think we're up to 25 Patreons. You are the backbone of this channel. Thanks for your support and your well-wishings, and all your comments are really appreciated. And if you ever have a question for Elizabeth or myself, that's probably the best place to do it. You can PM us there, or we also have the staplecrew.com. Okay, so as everybody knows, there's been a lot of talk about the footnotes and Mr. Deaton, and we think we've got the smoking gun maybe, and these different facts are starting to pile up, and we're all so excited about what's happening. And we know the 13th is coming. So we would like to get Elizabeth's perspective on this whole thing. So with no further ado, my lovely wife and talented wife, Miss Elizabeth, come up.
All right. Good morning, everybody. Thank you so much. This is a little impromptu, sort of, because we recorded all of this last night with the new share screen that I said was going to happen. And Zoom is a little more complicated, I guess. It didn't share the screen. It shared one screen. So when I clicked back and forth, there was no more screens. It was just one screen the whole time. So we're redoing it. I'm shortening it. I've got plans for other stuff. I'll tell you at the end, but I want to jump into it. So when I heard earlier, when I had hearings and interviews all week, so I wasn't even home. I was just barely looking at this or that. And I saw that as I called it, someone who kicked a chicken coop, like what's going on what's the footnote? I said, it's a footnote gate. What's happening? We're winning again. Ripple's going to win. And this is it for the SEC. They're done now.
I've already spent $2 million in my mind, at least.
So the footnote, I said, okay, what's this footnote? Footnotes or footnote. So I went and I looked it up because I had the stuff with me and I've been studying. I want to bring you a whole bunch of, I want to unpack a whole bunch of stuff, as I said. Then I said, well, I better get into the footnote. So let me share, bear with me. We have to do this in step-by-step fashion, I suppose. Otherwise it doesn't work. So I'm going to share this with you. John Deaton. This was what kicked it off, the buzz, right? And I don't know when this was. May 20th or so. So yeah, he kicked the coop here, which is fine. And he said, here's the analysis I did on the reference Ripple made regarding the Hinman emails and Ripple's opposition and reply briefs. It's clear that things said in the Hinman emails specifically contradict arguments made by the SEC. The truth is Ripple didn't rely a ton on the emails. Well, that is an accurate statement. The last sentence is an accurate statement. The rest, I'm going to unpack for you here today. And it's just the thing that got me going, amongst other things. So it says, he's saying before reading the email, so that the courts read the emails, the parties have read the emails, they filed everything in redacted state. Okay. But the footnotes, okay, here's the footnotes, and that's what they.
Excuse me.
So we will learn things that are not cited in the briefs. Okay, well, we may learn those things, but if they're not in the briefs, the court can't rely on anything not in the briefs. Okay, so
good point.
Whatever on that. So now I'm going to stop sharing that, and then I'm going to have to share another different screen and go through this with you step by step. So first things first. Oh, sorry. I could have just been here. I'm sorry. I'm allowed to do, I can go just straight to this page. Stare decisis. Sorry to bring out the Latin, but it's really going to I want to give context to everything before I just lay you out. I don't want to tell you what to think. I want you to figure out how to think, instead of somebody just giving you the sound bites and saying, here, think this, we're going to win. Here, think this footnote is the smoking gun.
And incidentally, I really believe that's the following that we have. We have pretty high IQ people in our group. And I'm not just, that's not hyperbole. That's actually how I feel. You people have always read between the lines of everything I've had to say in all of my videos. I'm not just a pom-pom cheerleader guy. Here's the news. Oh, I think we win tomorrow. But you've been able to see the little nuances. It's amazing to me how many people post and say, oh, Allan, you didn't say anything in your 20-minute video. And I'm like, wow, that's amazing how many other people got so much content from it. That's really what Elizabeth's going to dig into, is those little tidbits that you and I know are there, but they're not hot points, and they're points that are so significant as to the way the judge is seeing this case.
Or has to by law. And also what you're not being told, what's not being presented, and you're missing the context you need to make your own decisions about it and really understand, you know, again, who's kicking the coop and why. And again, I'm over on Patreon because I don't want to
Right.
I don't want to be whatever inflammatory myself. So I just want to present everything to you. I would love your comments. Again, please comment if I'm way off base on something, unless it's in the receipts. If I'm off base on some pseudo prediction, then you can tell me. I know you'll be polite because that's, again, like the group we have. But stare decisis, very important principle of law in this country, is the doctrine that courts will adhere to precedent in making their decisions, stand by things decided. When a court faces a legal argument, if a previous court has ruled on the same or closely related issue, please keep that closely related issue in mind, then the court will make their decision in alignment with the previous court's decision. Okay? The previous deciding court must have binding authority over the court. Otherwise, the previous decision is merely persuasive. All right? And then you have horizontal stare decisis. It's courts adhering to its own precedent. For instance, the Second Circuit and the Second Circuit, I believe, is New York, okay? They follow each other. If there's something else, it would be persuasive, okay? I don't know how the F-sup cases work, meaning the ones that are from trial courts themselves. How, if the same trial court is bound by that. I tried to look it up this morning. I ran out of time. I apologize. The vertical stare decisis is when all courts follow United States Supreme Court cases. All. The United States Supreme Court trumps everything else. Everything else falls from that. California, for instance, Ninth Circuit Court of Appeals, even though it's in California, interestingly enough, is only persuasive authority. Okay, so we're in San Diego, say we're not in San Diego, but San Diego, I just know it, Fourth District Court of Appeal. So the trial court is bound by the Fourth District Court of Appeal and the California Supreme Court and the United States Supreme Court in that vertical order. And so United States Court, Supreme Court trumps the California Supreme Court, and so on and so on. Okay. So, and anything Fourth District would trump. But in California, like, the trial court wouldn't look to another trial court's decision, even in that same courthouse, as to what they're going to do. But persuasively, they're going to say, well, that's already been decided that way. And the Fourth District sort of, you know, we know what they're going to do, whatever. So persuasive, binding, vertical, horizontal, and stare decisis. I hope you'll understand why I'm taking the time to explain this to you in this way. And we're going to move on. So I have to stop sharing, start sharing again for the new thing that I'm going to show you. So the next thing I want to show you is let's go to where is it? It's not here. Oh, here it is. The table of contents of sorry about that. It was a little harder. It was easier when I could just open it from the list, but it would not let me share it with you, whatever. So this is the defendant's opposition to plaintiff's motion for summary judgment.
The robot vacuum
The robot.
decided this was a good time to get
My-
under our feet.
I'm closing it off. I'm sorry about that. Sorry. Stop, 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 stop. Okay. It's always good. Defendant's opposition to plaintiff's motion for summary judgment. This is their table of contents, okay? I might go back to this just to show you. I'm scrolling down. So this is their argument. This is where their argument is found for their, oops, sorry about that. Sorry about that. Section number 3, defendant's fair notice defense presents genuine disputed issues of material fact for trial. This is their argument. So facts, law, stare decisis, binding or persuasive, analysis, meaning talking about the facts and the law in a persuasive, argumentative manner to convince the court that they should win, okay? And then drawing conclusions from there. So that's what the court will read with respect to that argument, okay?
It has to be vertical in their district.
Vertical, as I explained,
Yeah,
trial court looks to Second Circuit,
Right.
Second Circuit looks to the Supreme Court,
Right.
okay? I use California a lot because I know California and I'm more confident in that, competent in that arena, but pay attention to the pages, okay? It starts on argument page 43, 44, 45, 47, 51. I know it seems all, yeah, this is really basic, right? But 52, 54, okay? We can come back to this if there's a question. Allan's really good at asking the questions that maybe you are asking, because even though he's been with me long time and knows more about things than he would like to, I'm going to share again. Sharing again, hopefully. Yes. Next thing I want to go to is let's look at their brief. Okay. Let's look at their brief next. The thing that Deaton was showing you, I excerpted something. Here's their argument as I showed you on page 43. Here's it all written out. Here's them talking about their facts and so on. And here's these footnotes, not the one John Deaton's showing you. I have them over here. Okay. So footnote, I don't know why it doesn't do that for me, but okay. Footnote 33. Okay. This was mentioned. The manager has concluded that the manager, I don't see court written there. The manager has concluded that none of Bitcoin, Ether, or XRP should be considered an investment contract. And the footnotes are all on the bottom, so they scroll to the bottom of the page again, the next page bottom. And none should therefore be treated as a security. The manager, I don't know who the manager is, you know, of KFC or whatever. I'm just being facetious, but I'm just saying it's okay. It's evidence. It's some evidence of something, but we don't know yet what it is. There are reasonable grounds to conclude XRP does not satisfy all the elements of the Howey analysis and therefore not a security for purposes of the federal security laws. That's in the emails. Who wrote the emails? Not someone from the court. Okay. Not someone from even if it's the DOJ weighing in or whatever, somebody, some agency weighing in. It's not the court. Analysis, therefore not a security, and so on. So that's what this is all about, okay? This is this whole thing. MoneyGram, counting treatment, didn't treat it as a security, okay? Same thing over and over. Here's another one of the emails that is here. Email evidence. Okay, lawyer receiving the speech because Himmons new test blacked out. Don't know what it's about. Here's 41. here's their statement of material facts, 56.1 in a footnote, SEC arguing that XRP is a security. Somebody's arguing it. It's not the court. Otherwise, it wouldn't be blacked out. Okay. XRP's largest stakeholder and therefore had economic incentives to make the price of XRP go up. Lit emails, XRP. So this is an interesting footnote. Sorry, I'm sorry.
Yeah, this is one.
This is an interesting
Yeah.
footnote. Let me stop. I thought I was just showing you something, but actually, how do I move this out of the way? Here we go. So a footnote is always attached to the body of the brief somewhere. So in the body of the brief, it's referencing a footnote to take the court and down here to read. It is likewise. So what they were talking about up here to take them down here was the SEC does mention the ability to use XRP immediately for cross-border payments, but now treats that as evidence supporting rather than contradicting its position that XRP was sold as a security. Compare something, their brief, the SEC brief at 3031, arguing that Ripple sold XRP as a security because users of Ripple's cross-border payment product ODL, everybody knows what that is here, probably on demand liquidity. Now I even know it. Yay. Held XRP for mere seconds while making cross-border payments with exhibit 226 at 5. So this is the evidence that they have to put in, explaining that an asset is unlikely to be a security if it can immediately be used to make payments. There's a footnote down here, not the one I'm going to show you. And then, but I wanted to give you the context. Otherwise this sentence wouldn't make sense.
Because it's then a currency or a coin or a commodity.
Okay. It likewise reversed it, meaning the SEC likewise reversed its own internal views about other factors that the SEC staff previously thought are blank, or even demonstrate that an asset is not a security, 41. And then they're putting here, I think for candor, but I'm not quite sure because things are blanked out, but compare 56.1 response, 1,667, just as my own footnote. That's how many paragraphs, if not more, were in their statement of material, undisputed material facts, whatever it's called in federal court. We'll get there when this is unsealed for us in the PACER. Okay, and then blank, 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 with SEC brief at page 3, arguing that XRP is a security because Ripple was XRP's largest stakeholder and therefore, quote, had economic incentives to make the price of XRP go up. Compare 56.1 respondent's paragraph of evidence 1669, exhibit 277, the lit emails, okay, at bait stamp number 470,969. Think about that in terms of everyone crying, why would it take them so long to do all these redactions and everything? Because they have to go through hundreds of thousands of pages and make sure everything, no one's name gets revealed that the court said shouldn't be revealed and so on. So blank, R blank, with SEC brief at 25, arguing that XRP is a security due to founder lockups in Ripple's XRP escrow. So not good evidence also found in those emails. But again, that's my own footnote, and you're going to understand footnotes better here in a minute. And then here's 46, the next footnote. And then this is the no action letter issue in a footnote, stuffed in a footnote. Okay, not directly addressed in the brief. The fair notice defense focuses on the agency's conduct, not the claimant's genuine dispute as to whether the no action letter process was viable, and so on. So this really has nothing to do with what John Deaton was pointing out as the smoking gun, saying it's a security, was able to dispute that it would have been futile to seek a no action letter. Okay,
It's
so
not a security.
that's the last footnote that I'll show you here. It had some blacked out stuff. Okay, So now I have to stop sharing.
I'm just going to put my guessing cap on for a minute. I think those words listed in there are coins, or I would assume they're coins, or commodities. That's the word that they're using in there.
Interesting.
I
Okay.
would guess.
Okay.
By reading it 5 times, I'm like, well, what else could he have said in there that they wanted redacted? Well, he's specifically calling it a commodity, possibly.
Nice. Nice. Okay. That's nice because I can't really figure out those. I can't make those guesses because I don't have enough experience, but that's great. So the next thing I want to show you is I want to go to Rudder Group. Okay. Now, man, I hope this is working.
Let's not shoot this for
I
the
know.
3rd time.
I know exactly. Well, if I have to, I'll just post it as is because I am reading the whole screen. So hopefully it'll work. But this is a Rudder Group. It's a very old Rudder Group. I'm going to just let you know that I bought this Rudder Group in 2001 when I was a brand new lawyer. Rudder Group is a Bible of Bibles for civil procedure, but this is admittedly only for California. It's all I could find in the moment, but the principles for motions for summary judgment are very similar, very, if not identical, in federal and state courts. They just have little nuances, differences with their rules, procedures, timing, but everything is a lot the same, like the mandatory statement of undisputed material facts is the same. How briefs get written is the same for everywhere. Brief writing is the same for everywhere you go. Okay. You have issue, rule stated from a case or a statute, analysis, bring in the facts, apply it to the rule, conclusion drawn by the writer. Okay. In general, that's just a very basic brief, but this is important though. So I couldn't find the analogous civil procedure explanation for this in federal under the time that I had available this week. So I grabbed this because the principles are going to be similar. I wanted to say that just as a very brief primer, so you know what's going on. When you file a motion for summary judgment, there's a notice, there's a little notice thing. Hear ye, I'm coming into court. I want to ask this court to throw out their case because of this, this, and this. Within the this, and this, the SEC has argued, okay, and let me get out their thing, all right? They've argued 1, 2, 3, 4 different things. And in general, the court can either grant the whole thing or partially. And I think, as I understand federally, you don't have to specifically say, I'm just moving partially, or I'm just moving for the whole thing, or whatever. In state court, you do. I think that you don't here. It doesn't really matter for the purposes of what I'm telling you, but when they use this motion for summary adjudication term in California, it's in this federal court, as I am learning, they use this term partial summary judgment. It's a much easier word than adjudication. Summary adjudication means partial, okay? So a partial adjudication means, okay, SEC, you win on, you win the issue of it being an investment contract, but you lose on this other thing. So summary judgment in favor of you for that issue is done, decided. We're just moving forward with these other elements of Howie. There's 3 more, whatever it is, 2 more, whatever it is. Public offering.
Yeah.
You know them.
Yeah.
Oh, reasonably expected a profit, efforts of others.
Yeah.
And all this stuff. I'm going to break that down. Go ahead, Allan.
I just want to interject right here. Clear this up for me. If you know, they have to prove all 4, right? The burden of proof is upon them.
Yes.
And they have to prove all 4 of these.
The burden of proof is on the plaintiff of every single case and in this case, it's the SEC. And so the court's naturally going to start as well with the SEC's stuff. And I've heard how we kind of divided out a couple of different ways, but there's 3 elements to proving
A security.
a security, but within that is one of the ways you prove it is with investment contract. The first 2 are not disputed. It's the investment contract that's at issue. And then the investment contract has 3 parts to it, or 4. Some people break out one part into 2. So it's 3 or 4. It just depends on what place you look. It's all the same though. So it's 3 for the main cause of action, but it's this, I don't want to show my middle finger. It's this investment contract that's getting broken out into these 3 elements of it. And
That's right.
I'm going to get,
Most of us are pretty clear on that.
okay.
Yeah, we're that far along. But
Yes.
well,
Well,
I just wanted
in
to
terms
clear
of
up.
briefing though, is what I'm saying in terms of proof. It's like, how do you prove Howie? 1, 2, 3. Be understood that the first 2, Ripple's not contesting that heavily. It's this investment contract 3. And then how do you prove that? It's 3 or 4.
3 legs of the,
Yes.
Yeah, we're pretty, I think we've been following this for quite a while. Yeah.
Perhaps.
Yeah.
Perhaps. I'm not so sure that everybody's figures that out.
We forget stuff.
Okay.
I mean, come on.
So why am I showing you this? Because on a motion for summary adjudication, meaning the partial summary judgment, as federals would call it, the statement of undisputed material facts, not just facts that are not significant, but material facts, that statement, and in federal court, it's called 56.1, must also tie each undisputed material fact to a particular claim, defense, or issue sought to be adjudicated. The specific cause of action, affirmative defense is what we're focusing on here today, which is the fair notice defense, claim for damages or issues of duty, shall be stated specifically in the notice of motion and be repeated verbatim in the separate statement of undisputed facts. When multiple causes of actions, issues, defenses are presented, each defense to which the motion for summary adjudication is directed must have a separate section heading indicating the issue number and specifying the issue. The headings must be followed by 2 columns and so forth and so on. Where undisputed facts pertain to more than one claim, defense, or issue, these facts must be repeated for each such issue. Okay. And so what does that mean from a state court point of view when the defendants, and the same, it goes to the same for their opposition. So when you're opposing a motion for summary judgment, this rule that I'm showing you on the screen here applies to your opposition as well. So in this one section of, you can't see it, but anyway, this is the, not the opposition, but if this was the opposition, their statement of undisputed material facts go in to the fair notice defense. Why am I telling you that? Because when you're hearing all the buzz all over YouTube with all these CNN style breaking news, footnote such and so says it's a security, we win.
Not a security.
It's not saying it's not a security. It's not saying it is a security. It's under the fair notice defense section, which means it pertains to fair notice defense. And once you get to fair notice defense, you've already lost on it's a security. So the fact that the manager or whatever other email said it's not a security is not relevant to showing that it's a security for purposes of Howie. It's relevant to show the defense that, hey, wow, it's a security. I've been misled. You confuse me. Anyone of ordinary intelligence couldn't figure this out, because it's strict liability on the Howey test. Okay. That's all. It's whether it's a security is a strict liability thing. So it's like, wow, whoops. Okay, man, you got me there. But hey, not fair, because it was vague. It was ambiguous. It was this, it was that. That's what those footnotes go to. They go and speak to fair notice defense, not Howey test. That's a separate, remember here, it's a separate specific claim or defensive claim. Okay. For them, it's their affirmative defense. Like, wow, it's a security. We didn't know. How were we supposed to figure that out? That's what that goes to. So that's what made me pause when I saw all this buzz kicking the coop again, saying, the smoking gun, it's a security. So I'm going to stop sharing this screen and let Allan speak while I get the next screen going.
I'm sure everybody, in a nutshell, gathers what she's trying to say here. What we're learning is there's so much stuff out there, and there's so many great points, and Mr. Deaton and many other people are coming up with some really good points. They are sensationalizing something in this particular case with the footnote that is, I don't know if it's false hope, but it's sort of like after the fact. Okay. That's not good. That's great. It doesn't even matter who the manager is. He might be, I don't know, Biden, but it's after it's been decided. That footnote then becomes really irrelevant to your situation, because it's not in the body of the work either, which we haven't even really gone over too deeply on that either.
No,
which is another factor.
I want to get there.
We're
I
not
want to
trying
go
to
there.
say that the footnote doesn't matter. We're not.
No, I'm not saying
what
that.
she's trying to say, and what she explained to me really well, was, okay, that's great, but that's great that your car has a new paint job, but it doesn't run. I mean, it's not running. That's great, but it's useless to you because it's a little late. I don't know if I explained that real well, but it was, for me, an eye-opener, because I always seem to think that everybody's on top of this case and everybody's got all the facts straight. And every time I bring these facts to Elizabeth, she looks at me and goes, well, okay, maybe. I mean, it's persuasive, but is it the law? Is it going to be ruled as the law? Is the judge going to be even able to consider those points? Or are those points way after she's already made her considerations on the important ones? And that's sort of an eye-opener for me. I was like, wow, you got to be kidding me. I didn't know it was going to be this difficult to defend yourself on something, but it truly is.
And remember, the emails, nobody saw those emails. So how could they rely on something they've never seen? I don't know. They're trying to rely on those for, you misled us. That's my words. I'm just paraphrasing what's going on, but we were misled to believe this, except you're showing them, and perhaps that's why in a footnote, something they never saw. So next, I want to, I think, finish up with my final, what do you call it? Coup d'etat? No, I don't know. I don't think it's a coup d'etat.
No, you were calling it Footgate.
Footgate. So no, this is just a little last thing to show you that I'm not sure that the footnote is the smoking gun. I didn't have, it wasn't the smoking gun that I thought. It was a lot of emotion, and it was more emotional than relevant. It's relevant. It's not the right word. It's just, stuffed in a footnote. So what are footnotes? Writing clearer legal briefs, use footnotes sparingly. Okay. Why is this? So this was last November. Judge Beth Labson Freeman of the United States District Court for the Northern District of California rejected a filing from class action attorneys who had stuffed 76 footnotes into a 25-page brief. This one, again, is a little extreme, but the points being discussed, that points being discussed now in this article at the San Francisco Bar Association. And let me tell you, legal brief writing is the same all over the country, whether some court has some local rule that they want 28 lines or 26 lines or this font or that font or this or that. The general principle of legal brief writing is the same. Okay. So Judge Freeman, who sits in San Jose, so I think that's ninth. No, it's a district court. So it's a trial court, federal trial court says, use footnotes sparingly and refrain from dropping citations into them. Citations, she means legal citations. That's fine, not citations to evidence. But why are you dropping footnotes with substantive evidence in them? That's just, I'll leave that out there. A brief rife with substantive footnotes is a poorly composed piece of advocacy. What is a substantive footnote? Something that you believe helps you win the case, not a reference to something as a convenience to the court so they don't have to go off and look something up, or perhaps something that you don't really want to highlight, but you probably need to throw in there to be candid. You have to have you have to be candid with the court and bring out things that you might not want to, or sometimes just for convenience. I'm saying, when I say section 21, Judge, all the way through this brief, I mean Penal Code section 21 or whatever, just different things like that. It's not that you can't use them, but you don't put your substantive arguments, the ones that are material, the ones that you're trying to use to persuade the court in them. And I'll back that up. The reasons for avoiding substantive footnotes should seem obvious. They impede readability. They distract and potentially irritate the reader. They interrupt the flow of the logic and the language, make it harder to follow the argument. The more difficult it is to follow the argument, the less likely it will prevail. Legal brief writers should never relegate an important point or argument to a footnote, which by its very nature signals the text contained within is of lesser significance than that in the main body. If you want to make sure someone doesn't read what you're writing, put it in a footnote. The human eye passes right over it. So they're saying don't do it. Do not put supporting points for your argument in a footnote. If it's self-evident, you don't need the footnote. If it's not, then you need it up in the main body. Lawyers shouldn't put substance in footnotes, okay? So that was repeated throughout this article. I don't want to read the whole article to you because that's not necessary. I think the point, I've made the point, I've beat you over the head with it, okay? And I'm just trying to show you that why I was suspicious when the footnote, we win, it's a security. I don't think that footnote is evidence that XRP is a security. The evidence whether or not XRP is a security comes from, and it's the SEC's burden, it comes from, we'll look at this again, but you can't see this anyway. It comes from the argument of SEC that it's a security. They have their burden. First has to make the burden, and then the XRP can come in and say, or Ripple can come in and say, no, you're reading that wrong, or I've got all this other evidence or whatever, and create disputes. So the argument is Ripple offered and sold investment contracts. Defendant violated section 5 when they indirectly offered and sold or directly sold XRP in public distribution, and 3, and then there's the subcategories under that. So that's dealing with security. Is it a security? And then Ripple has to respond to that with specific evidence. Did Ripple respond to that with specific evidence that, the emails prove that it's not a security? I don't think so, but we can certainly, I don't think so. It's a lot of brief. It's like 200 pages just for the FCC's filing alone. So next, I want to just make sure that I've covered everything. 1 second, the table of contents, you understand that with respect to the Rudder Group explanation of partial summary judgment and briefing rules, the opposition to the argument. I showed you John Deaton's stuff. I showed you the footnotes, what is a footnote? What is it useful for? The John Deaton, what kicked it off? It was other people too. I'm picking on John, but that was just what I
I
found.
don't think you're picking on John. You're just pointing out that a lot of people take what he has said in the public eye and said, oh, well, we win, give us our money,
That proves it's a security. And I'm saying,
yeah,
I don't think so. I don't think that's proof that it's a security. I think it's proof, perhaps, maybe that they were misled, but maybe it's in a footnote because they didn't have it to rely on before they made the decision to play cat and mouse with the SEC on the security issue. And that's only my opinion. That's not Allan's opinion, but that's how I see the game that was played between the two of them. And and again, Allan and I have talked about this too. Like, so what if they lose? What if the pre-sales are a security, the secondary sales are not a security, and the fair notice defense? I don't think they can make it on that, but maybe they can.
Yeah.
I don't know. But even if they so that means they kind of lose, they pay their fines, they do this, and then it's registered. I think that either way, the value goes up, as Allan was saying. Perhaps, maybe, it's not financial advice. Don't buy or sell anything because I say it might go up, but he's just saying, so what? We lose, we win, we win, we win. Maybe that's what's going on here.
I'm kind of saying that, but I'm kind of not saying that.
All right.
I could do 3 shows on that statement right there easily. And I'm going to, by the way, because I do have my opinions as to what will happen when if it were to become, well, I almost said that, if it were to become a security and if it didn't. Both of those are completely different stories as life goes on. I'm talking decades from now, how important that would be. You can't just brush over that in some little 5-minute statement. I've really put a lot of time and a lot of thought into both sides of that. And I'm one of the few people I know of that's even considered the fact that it could be a security. And when it is a security, what does that mean to you and your life and your family?
Right.
And I mean globally, not just in America, because everyone says, oh, we'll just leave America. Yeah, it's not that easy sometimes.
All right. So I want to wrap it up here. Hopefully I've kind of I've led you down the garden path, my own garden path, what I view as a garden path. Remember, my philosophy of life, or my take on the world, or my understanding of the world is way different than Allan's in a lot of ways. So we don't care. He's Mary Poppins. I'm not. And that's fine.
I've been called worse.
He knows that about me. So I have a couple of things in mind. I hear that the library secondary sales thing is the new.
It's not new. We've been talking about that for a long time.
Not the new, but there's a new,
Yeah.
Somebody kicked the coop again, saying that somebody's going to come in and change the motion for judgment, summary judgment order to read that it doesn't involve secondary sales and that the judgment is open. I want to look at that. I haven't looked at that yet, but I hear that's the buzz. I've been gone at hearings all week, and I've tried to bring something to unpack that footnote issue. So I want to go there next. I want to go through the substance of the case. I don't know if I'm going to beat her to the punch or not on it, but I would like to do a series on the whole fair notice defense, because some of this may be really important to them. All the other crypto companies, or whatever, I don't want to call them the wrong thing, have someone shoot me, but have been losing on this issue. And I wanted to really unpack the briefs with respect to fair notice defense, starting with SEC's motion for summary judgment. The next thing I wanted to do is move to the Howey elements. And those are long videos if I did them all together. So I was going to do them in like a series.
Yeah.
of sections, because each brief has a section, A, B, C, and different sections. So, and I'm bringing every citation I wanted to show you. It's very, very interesting, and help you critically think about it instead of just, oh, he said it, so that's he must be true, or they said, or I saw on this YouTube thing, or this YouTube thing.
It's now law.
Repeated this YouTube thing, which repeated this Twitter, which repeated this thing over here, which somebody took out of context. So that's kind of what I wanted to do. If you have any questions, like I said, please, we read comments. Allan loves to read the comments. I read them when I have a chance. He's going to be gone, so I'm going to be farm duty. I do want to start the series on the fair notice defense. If you've got a burning desire to know something, or for me to unpack something, if you just want my opinion, I can't do that. I'm not that. I don't operate like that. I have to kind of.
She gives little bits and pieces that you can read.
I have to get the evidence though before I'll make that for lack of a better, educated guess. I want to make an educated guess or prediction.
Yeah.
And some of my so-called predictions remain the same. Some of them I'm modifying. I said, look, sure sounds like they're going to trial. And now I realize maybe the trial issue is with respect to one of the elements or one of the issues. And I saw that in some briefs, which was very interesting. I read so much and I started learning. I was texting Allan all week because I was down at the prisons, and I was like, oh my God, did you know this? Did you know this? He's like, no. And then he would call me and then we would talk and go, wow, whoa, where'd you find that from? Oh, this case or that case, or.
Yeah.
So that's where we're going. So Allan, why don't you finish up and we'll get you on the road.
You were doing just fine. Okay, I'm going to, speaking of getting on the road, I've got to go. I'm headed to the boat. I'll be on the boat this weekend. I'll probably shoot some video from the boat, I'm assuming. Maybe a tour. Somebody asked, I can't even remember who asked me to walk around the boat with a video camera one day. And I might just do that if the weather's nice or whatever. That's coming up. I have an XRP video coming out. Go figure, hard to believe. And it's kind of a little different twist that a lot of people haven't been really thinking about lately. And it's really kind of been on my mind, and I really want to get that out. So that one will be out to YouTube. This, what I'm working on with Elizabeth, is going to always be on Patreon, because you are the family. And also, I'm going to further my story from the other night that you just watched, about the people I know, who they knew, why we know things. And I'm building the story. I know it's a little bit slow, but I'm trying to make this so when people come along, Patrons come, 100 or 200 people from now, we can reference back as to, well, why is he talking about all that? And I built the story sort of slowly. I hope that makes sense. So with that, until next time, please give us some really good questions. Be careful, because my wife is really a deep diver. Okay. So if you ask her about something, you're going to get, hey, you're going to get an explanation that's going to, you be prepared that if it's something you want to really know a lot about, okay.
I won't be able to give you an instant response. I'll say, great. Okay. I love the topic, and I need to find the answers. I don't want to just.
No, but she's not a sugarcoater at all. So you better want the objective view, or you want to think about something. Think about it for yourself instead of just going along with the herd. Okay, we are critical thinkers in this group, and if she and I have a disagreement, which we do all the time on so many different things, it's not that she's wrong. That's not the way we live our life. Okay. Yeah, she's never wrong. But like, can you imagine being married to an attorney? Like, how many arguments do I get to win? I mean, I really got to fight this out just to, survive around this place. I got the dogs. I lose that battle too. Forget about it. All right, guys, we are now rambling on for sure.
Sorry
I hope
about
you
that.
guys are getting something from this.
And sorry about the thumbnails. My secretary knows how to make the thumbnails work on Patreon, and I don't. So when you see the shady gray, that's me screwing it up. She'll be back on Monday. And
It's weird because I put the thumbnails in my videos and they always come out great. And I don't know why that one didn't, but
no, the two that I posted on Patreon don't work. The one that Christina posted on Patreon works. So I have to, she's back on Monday and I'll get her to educate me on that.
Okay, guys.
All right.
I'll be talking to you guys real soon.
Thanks, you guys.